Welcome. First, we'll set the stage for what the 60-day grace period means after a layoff for H1B workers and how to navigate transfer risks. Next, we'll outline what triggers the clock, how to file fast and correctly, and what to disclose to attorneys. Finally, we'll wrap with actionable steps, diagrams, and quizzes to reinforce your understanding. To begin, we will provide a roadmap of the key decisions involved in the 60-day H1B grace period after a layoff. Then, we will explain how timing, filing, and disclosure all interconnect so you can make informed, defensible choices under pressure. Now that you know the scope, here is the agenda. First, the 60-day rule. Next, when the clock starts. Then, filing strategy and the disclosure dilemma. Afterwards, a step-by-step action plan. And finally, we will review with diagrams and quizzes. Before we proceed, please note this content is educational and not legal advice. Your facts may differ, so consult a qualified immigration attorney to evaluate your particular situation. With that in mind, let's move forward to key terms. Let's define key terms. The 60-day grace period begins after an involuntary termination. The crucial date is when you stopped performing work duties, which may be earlier than your severance end date. An H1B transfer, filed on Form I-129 by your new employer, must be filed within that 60-day window. Being on active payroll with ongoing work can indicate continued employment. Severance alone is passive and does not typically delay the clock. As a conservative practice, assume the clock started on your last day performing work. Next, we'll visualize how the start date is decided. This flowchart shows how to identify the true start of the 60-day clock. First, after a layoff event, ask whether you are still performing work duties. If you are, and you're also receiving regular payroll and benefits, employment may appear active and the clock may not have started. However, verify with HR and legal counsel. If you're not performing work or only receiving severance, the clock likely started on your last day of active work. A warning emphasizes using the conservative date if there's any uncertainty. Now that we've established the start point, we'll move to timing strategy. To assess risk, consider 4 contributors. First, uncertainty around your last day performing work increases timing risk. Second, assuming severance delays, the clock can cause missed deadlines. Third, late or incomplete filings increase exposure. Fourth, weak documentation raises the likelihood of a request for evidence. Next, we will test your understanding with a quick quiz. Quiz time. Which date is the safest conservative start for the 60-day grace period? A. The date severance ends. B. The date you stopped performing work duties. C. The date your benefits terminated. D. The date your new offer letter is signed. You may pause the video now to think about the answer. Real dig. We will discuss the answer in the next section of the video. The correct answer is B, the date you stopped performing work duties. This conservative approach helps ensure you do not mistakenly rely on severance timing that does not pause the grace period. Next, we'll map the full 60-day timeline to plan your filing. This timeline shows key windows. Day 0 is the last day you performed work. The first week is for document gathering and confirming the termination date. Days 8 through 21 involve offer and onboarding with the new employer. Days 22 through 35 focus on petition prep, including the labor condition application and support letters. Aim to file by day 45 to preserve a buffer. Ensure your receipt notice is issued before day 60. Premium processing may be optional, but speed is crucial. Now let's cover the filing strategy in detail. The filing strategy centers on speed. Once you have a signed offer, push to file the I-129 transfer quickly. A timely receipt generally allows you to remain in the U.S. while the case is pending. Premium processing can provide predictability, but does not replace the need to start early. Keep strong evidence of your last day of work, pay records, your offer letter, the labor condition application, and status history. Coordinate early with HR and attorneys to ensure all milestones are hit. Next, we'll translate this into a 48-hour action plan. In the next 48 hours, confirm your termination date in writing and default to the last day of active work if anything is unclear. Assemble all key documents, including prior approvals, pay stubs, I-94, passport, resume, degrees, and prior LCAs and petitions. Share precise facts with the employer's counsel and request expedited drafting and posting if needed. Align on a filing target to achieve a receipt by day 45 to 50 or earlier if there is any ambiguity. Decide on premium processing based on your start date needs and risk tolerance. Keep meticulous logs and confirmations.
Next, let's tackle the disclosure dilemma.
Here we contrast two approaches. The conservative view calls for full disclosure of the layoff and precise termination date, which maximizes defensibility and reduces the chance of a request for evidence or denial, though it may introduce short preparation delays. The expedient view applies in a narrow case. If you are still on active payroll and performing work, the record may appear continuous. However, risk increases sharply once payroll stops, and any misrepresentation can create significant long-term issues.
Next, we will visualize a disclosure strategy.
This mind map centers on the disclosure strategy. The conservative branch emphasizes full disclosure, precise termination dates, strong documentation, and reduced request for evidence risk. The expedient branch applies narrowly when active payroll and actual work continue, ceasing once payroll ends to avoid misrepresentation. Evidence includes pay stubs, termination letters, I-94 history, and prior approvals. Timing focuses on filing as soon as possible and achieving a receipt before day 60, with premium processing as an optional accelerator. Integrity stresses consistency, verifiable records, and alignment with counsel.
Now let's reinforce this with a quiz.
Here is your second quiz. If your layoff already occurred and payroll has ended, what is the best disclosure approach? A. Do not disclose to avoid delays. B. Disclose fully with precise termination date and evidence. C. Disclose only if USCIS asks later.
D. Wait for severance to finish before disclosing.
You may pause the video now to think about the answer. We will discuss the answer in the next section of the video.
The correct answer is B.
Disclose fully with a precise termination date and supporting evidence. Once payroll has ended, transparency is necessary to protect the integrity and defensibility of the filing. Next, we'll provide a documents checklist to keep you organized. This table provides a practical checklist. Prior approvals establish status history. Recent pay stubs show maintenance of status, especially your last active payroll. Your I-94 confirms your latest admission and class. Passport and visa pages demonstrate identity and travel history. Resume and degrees support qualifications and include evaluations for foreign credentials. Termination letters or emails document your last day worked and should include the date in writing. The new offer letter provides role details, ensure title and classification alignment.
Finally, LCA posting and proof confirm wage and worksite compliance.
This sequence diagram outlines the communication path. The candidate accepts the offer and provides documents to employer HR, who initiates the case with the immigration attorney. The attorney requests any missing information, drafts forms, and the labor condition application, then files the I-129, optionally with premium processing. USCIS issues a receipt to the employer, and HR relays the receipt and start guidance to the candidate. Notes emphasize filing before day 60 and disclosing the precise termination date. Next, we will call out common pitfalls to avoid. Avoid these pitfalls. Do not wait for severance to end before counting the clock. Do not assume premium processing can fix a late filing. Provide consistent dates to counsel. Begin document collection immediately, rather than waiting for the labor condition application. Finally, verify your I-94 details, especially after recent travel. Now, let's summarize the most important takeaways. Here are the key takeaways. First, use your last day performing work as the conservative day 0. Second, file the I-129 transfer promptly and aim for a receipt before day 60.
Third, once payroll has ended, full disclosure is the safest approach. Fourth, maintain robust documentation to withstand scrutiny. Fifth, combine speed with accuracy to minimize risk. Next, we will present a quick visual recap of the decision logic. This flowchart recap starts with whether you are still performing work. If you are not, assume the clock has started and file as soon as possible. If you are still working and on active payroll, verify facts carefully, avoid any misrepresentation, and continue to prioritize speed. With this logic in mind, we will now conclude with a concise summary. In summary,
Count day 0 as your last day performing work, file early to secure a receipt before day 60, and be transparent with counsel once payroll ends. Support your case with strong documentation, and plan backward from day 60 to maintain buffers.
Finally, we will close with a quick thank you and a call to action. Thank you for watching. If this video was helpful, please like, share, and subscribe. Share your scenario or questions in the comments so we can discuss and help others. See you in the next video.